Welcome to the latest episode of Call to Account. One of the downsides of the COVID-19 pandemic has been an uptick in shareholder disputes, with cash-strapped business owners seeking to exit the business or look for ways to extract additional value by exploiting the shareholders' agreement. Shareholder disputes can be expensive, they're emotionally charged, but they're also avoidable. This video looks at two of the more common causes of shareholder disputes that I've seen recently and suggests some ways shareholders in private companies can reduce the risk and scope of costly future disputes. Now, while the underlying causes of the disputes are not specific to COVID-19, the most common themes I typically see relate to 1. Poorly drafted accounting terminology, and 2. Valuation approaches and dispute resolution processes that aren't well articulated in the shareholders' agreement. Now, looking firstly at poorly drafted accounting terminology. As a forensic accountant, I see disputes of this nature often. When you're starting a business with a friend or colleague, the last thing that's on your mind is that you'll fall out over how you'll run the business, who's going to be doing what, and of course your compensation. You're looking to pull something together rather quickly that you think best captures your intentions. Sadly, what often emerges is a confused accounting phrasing and terminology that leaves this forensic accountant scratching his head trying to make accounting sense of what was written and agreed by the parties. Now, when it comes to these types of disputes, I'm restricted to interpreting the relevant clauses by reference to accounting standards and practices, and I can't have any regard to what was intended by the written clause. Valuation disputes, on the other hand, occur for a variety of reasons, including, for example, the retirement of a shareholder, or a shareholder feeling that he or she is doing all the heavy lifting. A worst case scenario, and one all too familiar with private companies, is that there is no shareholders agreement. At best, there may be a shareholders agreement. However, too often, such agreements are silent on valuation approaches, trigger events that might prompt a buyout or share transfer, and they typically don't have a process for resolving the valuation dispute. So you're in a dispute, and you're in a shareholder dispute. What can you do now? Unfortunately, when a dispute arises between shareholders, there's not a lot you can do at that point. A negotiated settlement is the best course of action. In valuation-related disputes, understanding the context of the dispute and the intrinsic drivers motivating the dispute can sometimes help me generate solutions that might be appealing to all parties. For example, structuring the buyout with an earn-out can help overcome the reticence of, say, the retiring shareholder, as it might provide him or her with a short-term reward and income stream for the past efforts that they've spent in building the business. Alternatively, breaking the impasse by seeking interest from a competitor or other third party in acquiring your shares might help bring the other party or parties to the negotiating table to agree a commercial outcome. And that's, of course, assuming that sort of going outside of the company is not prohibited in the shareholders agreement, if there is one. At the extreme end, applying to the court to wind up the company on just and equitable grounds or for oppressive conduct are also possible outcomes. However, this can lead to permanent value destruction in the business should you be looking to start it again in the future. However, courts are typically quite reluctant to order the winding up of solvent companies. And of course, simply leaving and starting up a competing business is really not advisable, as this exposes you possibly to breaches of directors' duties. So before you get to the dispute, how can you proactively manage the risk of future dispute? I suggest that the most effective way is to review the currency of the existing shareholders agreement, or get one drafted, with the appropriate legal and accounting advice. Now, there are a number of reasons why renegotiating or implementing a shareholders agreement is commercially sensible, including, for example, Checking out to make sure that the accounting terminology and the definitions used in the current version are being used correctly and that they are delivering the intended outcome. Now, is it justified by the business being different in terms of size, nature, and scope compared to when the business was first established? Now, are the founding shareholders getting older and looking for an exit? Are the younger shareholders looking to take the business in a different direction? Or are the existing shareholders looking to bring in new shareholders? Now, what relevant valuation trigger events have been or should be included in the agreement to ensure a smooth transfer of the shares? For example, on the death or retirement of one of the shareholders. And finally, is there an effective dispute resolution clause in the contract that outlines the valuation process should a dispute occur? One of the most common areas of private company valuation disputes is the discount or premium that is applied to the discount rate. This can effectively be addressed, however, by including an explicit clause in the shareholders' agreement that all shares rank pari passu. And finally, if you are looking to include language in the agreement about valuation methodologies, approaches, or formula, I strongly advise that language is kept as broad as possible, if at all. What seems commercial now may not reflect market value in the future. Thanks for joining today, and see you next time.